Jaco, this employer says that an employee stabbed another employee with a stapler. Now, that's interesting. But stabbed the employee with a stapler during an altercation at work, but the fight took place outside of the work premises and after working hours.
Okay.
So what will you do?
So normally your rule of thumb is what happens outside of the working place got nothing to do with the employer. It's not in the course of employ. However, if you can prove a nexus that the reason for the assault outside of the workplace emanated from inside the workplace, so they had a beef inside the workplace and after hours, the employee assaulted the other one, you can still charge him with assault. It's still misconduct because it links to the working relationship. It links to the workplace. It emanated from the workplace. So the fact that it was after hours doesn't excuse the misconduct.
It's not as simple as it appears to be.
No, you have to prove the nexus. You have to prove the link. Then you can still charge the employees. If it's unrelated, they're at a bar and they're disagreeing about a soccer game and beat each other up, it's got nothing to do with the employer. But if there's a link to the workplace, to a fight in the workplace, to a disagreement in the workplace.
If they had an altercation at the pub, two of the employees, and the one pitches up tomorrow morning with a blue eye, and he can't work, her job is at reception with the blue eye, does that make it more complex?
It does make it more complex, but that's a different scenario. Then you can't work. If you can't perform your duties, then you're going to be sent home and not paid. Because you can't tender your services. That's basically illness then. But the fact that you got injured outside of the workplace got nothing to do with me.
Jaco, I've got an email here. It says that two of this employer's employees were engaged in a physical fight. It was during working hours. They used vulgar language according to the employer. They had uniforms on. It was during working hours that it happened. Somebody else recorded that and published that on TikTok. How will you deal with this case?
All right. Yeah, thank you, Gerrit. I think there's two issues that need to be addressed. The first issue is obviously the fighting in the workplace, which is unacceptable behavior. I assume that the employer will have a disciplinary code in place stating that fighting is not permitted. So that is very serious misconduct, and those two employees should be charged with assault, and which may well lead to their dismissal. It's a very serious misconduct.
And if the employer doesn't have a code?
Well, this is probably one of those misconducts or actions which is so well known that the employer should have known that they are not permitted to fight at the workplace. So that argument can be made to say, well, you should have known it, even if it's not strictly contained in a code or policy, and therefore you breach the rule. Because one of the requirements of the labour law for substantive fair dismissals is that the rule must be known. So if there's no policy, then at least you must be able to convince a commissioner or a chairperson that the rule is a kind of a common law rule, and the employee should have been aware of it and therefore should have known they should not breach it. That's the first issue. The second issue is obviously the video recording that was placed on TikTok by, I'm assuming if it was during working hours, by another employee. The fact that the workplace could be clearly identified, the vehicles of the employer was in full view, the employees was in uniform of the employer, obviously identifies the employer quite clearly to anybody watching the TikTok video. So that employee who posted it should have also realized that his conduct will bring the company name.
He's also in trouble.
Yeah, because his conduct will bring the company name into disrepute. Because what are people going to think about this employer and his employees fighting in the workplace using vulgar language? So he should probably be charged with bringing the company name into disrepute by his actions.
But it is complicated. We don't know what's happened between the two employees and what's caused that and
yes,
so on.
Absolutely. We don't know what led to it.
What led to that, yeah.
Who was provoked or what might have had. But that will come out during the hearing, obviously.
Yeah.
Hello. I operate a TS company and have a couple of employees working at one of my clients. They've been working there for more than 4 months. One of my clients does not like one of my employees, and he has now shut him off the premises and disabled his access to the premises. What can I do now?
Okay, Yaku, that's my kind of employer. He doesn't like that employee, and he says, "I don't want you on my premises. You're not in my employ." He thinks might be his thinking, and get off my premises.
Yeah.
Temporary service employer is involved.
Yeah.
What
This is a very complicated situation. It's not uncommon, but it is complicated. Due to the complicated nature of the relationship between the TES and its client. Prior to about 2018, the relationship was that the employee of a TES remains the employee of the TES, and the TES simply places that employee at his client. And the TES is responsible for discipline and all that. After 2018, the Constitutional Court interpreted what they call the deeming provisions of the Labour Relations Act, and basically said that the provision in the Act that states that after a period of 3 months, the employee of a TES is deemed to be the employee of his client, should be interpreted that the client now becomes the sole employer of that employee for purposes of the Labour Relations Act. That's the one aspect. And that has been interpreted recently by the CCMA to mean that the TES can't even discipline this employee. It's the responsibility of the client to discipline him. So the fact that he is a TES employee or a deemed employee does not take away his right to fair labour practices. So that, if that interpretation of the CCMA for the Commission is correct of the assigned services case, then the TES can't do anything. The client should actually discipline that employee or have a valid reason to discipline him, have a hearing, charge him with misconduct, whatever the case might be. We don't know the facts why he doesn't like him. But that is the responsibility of the client now, it seems, not that of the TES. The second issue with this is this is what they call a dismissal at the behest of a third party, where there's a commercial relationship between the TES and his client, and part of that commercial relationship says that if the client doesn't like the employee, I can tell the TES and he must remove him. That, the court has said, is not a valid agreement. It's not a valid clause because it undermines the constitutional right to a fair labour practice. If there's not a fair right to remove that employee, a fair reason, I beg your pardon, to remove that employee, the TES cannot do it. And the court has gone so far to say that the TES should take his client to court to prevent him from forcing him to remove that employee. If there's a valid reason, it can be done, but if there's no valid reason for the dismissal, it's not permitted.
To an extent, that defeats the object of employers making use of temporary service providers.
And unless it's a true temporary service, unless it's for a period less than 3 months, or for a position, somebody that's filling in temporarily for somebody that's absent, or unless there's a collective agreement that states that this type of position or this type of job is of a temporary nature. That's the only scenarios where it is not regarded as permanent employment after 3 months. And that's the only scenario how TES can actually perform in the labour market at the moment.
The point is, Yaku, employers used to make use of temporary employment service providers to escape the responsibilities that they had in terms of the normal employer-employee relationship. But this is clearly very complicated now. So it's almost dangerous if you're under that impression that you can dismiss easily.
The court says you can't deal with people as commodities any longer. That's the reason for this change, or this shift in policy, rather. People cannot be seen as commodities, and you cannot take away their rights.
Good day. I would just like to find out. Our employees were caught drinking and posting photos on WhatsApp statuses after hours using the company's vehicle. One of our employees do have permission to use the company's vehicle for transport to and from work, and the other employees do not. What are the employees charged with, and are all the employees charged?
So basically what this person is stating is that her employees were caught or posted WhatsApp videos of them being in a company vehicle after hours drinking and having a good time. And the person, I'm assuming, driving has got permission to use the vehicle to drive to and fro from work, but for nothing else. So the question is, should they be charged? Can they be charged? And should all of them be charged? The obvious one is the person who's got authority to use the vehicle will be charged and must be charged for unauthorized use of the vehicle. He's got permission to use the vehicle to and fro from work, not to go gallivanting with it and go drinking in it. So he should be charged for that, and possibly even drunken driving, if that can be proven. In respect of the rest of the employees, it might be a bit more difficult because we don't know what they know. They possibly don't know that they're not allowed to use the vehicle. They possibly don't know that it's a company vehicle. If they are aware that they're not allowed to use the company vehicle, same charges, unauthorized use of a company vehicle.
If you're an employee and the offer is made to you to accompany somebody in a company vehicle going to a pub, you see as a company vehicle, the chances that you're supposed to know that you can't be there. So
absolutely,
on the balance of probability, somebody might say you should have known that.
It's going to depend on the circumstances, really, and especially if it's a branded vehicle as well. Then you're back to bringing the company into disrepute.
Then you should have known. You should have known.
Yeah, really depending on the circumstances. We don't have enough facts to really determine it.
So in order to avoid any uncertainty in terms of this type of thing happening, what do you suggest employers do?
Well, you should have very clear rules in your workplace. That's fundamental for any employer. To stipulate the rules. An employee must be aware of the rules. You can't charge an employee that he has broken a rule if it's not aware of it. As simple as that. So stipulate your rules in your contracts, have a disciplinary code, have policies on these things, and make sure everything is codified so your employees know what they're not supposed to do and what will happen to them if they actually contravene those rules.
The manager of this employer is engaging in a sexual, romantic relationship with a junior employee.
It's always a tricky one. An employer can't really regulate relationships. And I'm assuming that this is a consensual relationship. If it's not consensual, obviously we're dealing with sexual harassment and all those kinds of issues. What an employer could possibly do is, if they have a policy in place stating that if you have a romantic relationship, particularly between a senior and a subordinate, certain steps need to be taken in terms of possibly reporting lines and who takes decision in terms of this junior employee and all those kinds of issues. Naturally, if this relationship goes sour, there is an issue after that in terms of working relationship and the working environment. Then we can possibly start looking at compatibility issues in the workplace. But I'm making a lot of assumptions here that this will happen. But you can't regulate the relationships of employees. That's the
complex
crux of it.
issue.
It's a complex issue.
Yeah.
You can't regulate it, but it's always dangerous when you have especially a senior and a subordinate in a relationship, because it might open the employer up to sexual harassment and sexual misconduct charges. Because the employer, in terms of the Employment Equity Act, is responsible to prevent sexual harassment. So it's a tricky situation.
We got one of our employees using his cell phone. However, when we went back to our old footage, we saw that most of our employees are playing on their phones, watching videos, while they're supposed to do their work. Will it be allowed for us to force them basically to put it in their lockers or implement like a policy or something that can perhaps work for us? We're not quite sure.
It's the employer's full right to implement a cell phone policy stating that you're not allowed to use your cell phone during working hours. It impacts on productivity. It might be a safety risk where employers are not paying attention to whatever machines they are working. So the employer is in the full right to implement a policy, which suggests that he consults with the employees before implementing it, and then implement it.
Consultation doesn't mean they have to agree to whatever you're about to.
Consent is not required. It's a workplace policy, and employers can implement policies in the workplace.
Yeah.
They can require them to place it in their lockers when they come in. I would suggest that the locker should be able to lock, just to avoid further issues where theft might occur and all that. But in essence, to implement a cell phone policy to increase productivity and safety is absolutely perfectly fine.
There are a few things that causes more frustration at work for employers and co-employees than cell phones. The sound of cell phones in the workplace is frustration, and I think it's a good thing for employers always to have very strict cell phone policies.
Yeah, it's disruptive.
In short, what this employer is saying, that an employee went off sick. It later appeared that the employee during that time, she was in fact pregnant and she gave birth to a child. Now, the employer later established that during that period of her absence, she introduced a sick certificate, but it was for giving birth. What is the difficulty here?
Yeah.
For the employer or for the employee?
Yeah, so the difficulty is that in effect, the employee was dishonest. I mean, you can, to some extent,
I think the employee just needed the money and she wanted...
I understand that, but unfortunately, the law is quite clear on this. If an employee is pregnant, she needs to go on maternity leave at least 4 weeks before the time and stay off at least 6 weeks after birth, unless a medical practitioner says she's fit to return to work. The problem with not disclosing that or giving a different reason to the employer is that there are certain obligations in terms of both the Labour Relations Act and the Occupational Health and Safety Act on how to treat pregnant employees and how to safeguard them, how to not expose them to hazardous materials. And the employer needs to know that she's pregnant in order to keep her safe at the workplace, effectively. So her dishonesty by lying to the employer actually placed the employer at a peril because he could not comply with his obligations in terms of the Act. So it's actually a very serious misconduct in my view.
But, seeing it from the side of the employer, you didn't know. If you don't know, you don't know. If you're an employer and employee does that and she says to you, sir, I did that because I cannot afford that period of absenteeism inter alia because the UIF, the unemployment insurance, they're not functioning. I needed the money, that's why I worked.
Yeah, that will all be mitigating circumstances that the employer can take into account. But it does not excuse the conduct of being dishonest and placing the employer at a peril, and herself for that matter.
Yeah. Jaco, this employer writes the following. If an employee is absent for more than 3 days, question mark. Now, the question is wide open. What is the permutations that can play out here?
So we don't know, obviously, the reason for his absenteeism at this moment. He might be off sick. If he is off sick, the Basic Conditions Act requires that if he's absent for more than 2 consecutive days, he must provide a sick note. Otherwise, it will be simply regarded as being absent without leave, which is a misconduct. And also possibly failing to inform, if he did not inform his employer that he is going to be absent from work. Alternatively, if we don't know why he is absent, he has not informed, we don't know whether he is sick, it might be desertion. He might not be planning to come back to work at all. If that is the case, there's a whole different procedure to follow for the employer. He must try and contact that employee, send a notice to his last known address to tell him that he has been absent from work, he is deserting and he needs to return to work on a specific date. If he still does not make contact, a second notice for a hearing possibly. And if he does not attend the hearing and you can prove that the notice was served on him, the employer would be within his rights to dismiss him in his absence. However, there are some possible complications with that, because if that employee turns up 2 months later, it's not desertion anymore, it's simply absenteeism, and he would have to provide a good reason as to why he was absent. And it will be up to the employer whether he will accept that reason or not. So it's a type of appeal process that follows then as to why such a dismissal should not be made permanent. But it is quite a technical process, so it's something that employer will have to be circumspect about.
What is the time frame between the first and second notice by the employer to the employee?
Well, normally you would state that the employee needs to return to work by a certain date. If he does not return,
like tomorrow morning?
By tomorrow morning or by whenever. And then if he does not return, you can immediately issue the second notice and say, well, there will be a hearing on a specific date. Normally, you will have to give at least 48 hours notice of a hearing, but probably in this case, a longer notice period will be applicable or preferable, as we don't know where the employee is. So possibly 5 days or whatever the circumstances dictate, but a minimum of 48 hours notice of a hearing is required.
Jaco, this employer asks us the following. How do I protect myself against a negligent employee and the workman's compensation which has resulted in death of such negligent employee?
First of all, obviously the employer has got some responsibilities in terms of the Health and Safety Act to have certain safety measures in place depending on the type of industry he is in. That will differ. So as long as the employer has got the safety measures in place, he's got the necessary policies in place, he should be fine. He should be covered by the fund. If the employee is negligent, he does not follow the rules, he does not follow the safety policy, he does not use the tools or safety equipment, and he is injured or dies, the employer should be protected. There will be an investigation. But if the Compensation Commissioner finds that the injury or death is due to the negligence of the employee and that the employer complied with all his obligations, there should be no liability on the employer.
What if there's negligence on the side of the employer of non-compliance?
If it's not compliant with the regulations of the Health and Safety Act and the employee is injured, then he will be held liable. To a certain extent, of course, the negligence of the employee may play a role. But if it is found that it's due to the non-compliance of the employer, you will be liable for the death of that employee and the associated costs therewith.
Huge responsibility lies
absolutely
on employers in respect of each and every workplace.
Health and safety is extremely important in the workplace.
Jaco, this employer says the following. Due to issues with SARS, I cannot obtain IRP files for my employees. My one employee is now threatening me with the commercial fraud unit and posted it on his WhatsApp status. What can I do?
It's a bit of a difficult one if the employer really did not comply with his SARS obligations, but he has an obligation, first of all, obviously, to comply with legislation in terms of tax and to issue his employees with IRP 5. However, the fact that the employee posted this on the WhatsApp group could possibly be construed as bringing the company name into disrepute, which is a misconduct. Since SARS is already aware of this issue, obviously, I doubt that the employee will be able to hide behind a protected disclosure to say he made a protected disclosure and therefore he should be protected and not no action be taken against him. So in my view, that should be misconduct and he should be taken to task for it.
Even if the employer is guilty of some form of non-compliance?
Yeah, it does not mean that the employer's got a right to tell the world about it if it infringes on the reputation of the employer.